Good morning, everyone. I'm Kim Straker, and I want to welcome you to our HR Forum event today. We have a lot of interesting and timely topics to cover. I'd like to introduce you to my colleagues, Ashley Eman, Grayson Maranta, and Nick Lucier, who will be presenting today while I'll be moderating the Q&A. We have a PowerPoint that we've prepared to help you follow along during our discussion, and we'll be emailing it to you after the event. First, Ashley will be discussing the trends and statistics relating to audits and enforcement of the New York City Earned Safe and Sick Time Act, and she'll advise you on key takeaways from enforcement actions. Next, Grayson will discuss recent updates on new hire and posting requirements, but she'll spend most of her time discussing the New York Department of Labor's revisions to its model sexual harassment policy, which was actually just released last week. When we planned this event, we were hoping that the revisions would be finalized in time, and it worked out well. All New York companies must either adopt the new model or revise their existing policies to meet the new standards set forth in the model. So you'll hear all about that today. Finally, Nick is going to inform you about New Jersey's sweeping new law that alters the way employers may use temporary staffing agencies for particular job categories. If you have any questions during these presentations, please put them in the chat box. I'll be monitoring them, and we will try to address your questions at the end of each presentation. If for some reason we can't get to all of your questions during our designated hour, we've also set aside additional time for Q&A in separate breakout rooms that you can join at the end of our presentation. What'll happen is you'll see a prompt come up on your screen, and you can opt in, so you can select which breakout room you'd like to enter, where you'll be able to ask your questions live to either Ashley, Grayson, or Nick. If you're unable to join us in a breakout room, you can also feel free at any time to reach out to any one of us by email or phone with any of your questions. Last, we wanted to let you know that we're recording this event so that we can send the recording out to those clients who aren't able to make it today. I'll be announcing the CLE code later on for those of you who would like to get CLE credit for today. With that, I'm going to turn it over to Ashley to begin today. Ashley.
Thanks, Kim. So I'll kick us off with a pretty important topic here in New York City, which is the enforcement of the New York City Earned Safe and Sick Time Act. And just for brief background, the Earned Safe and Sick Time Act, or ESTA as it's commonly called, is the paid sick leave law in New York City that applies to employers with one or more employees. So it's very broad and applies to a lot of employers in New York City. Next slide, please. So we'll get into some of the specifics of the law in a little bit, but we'll start with who is the Department of Consumer and Worker Protection and what are they all about? So the Department of Consumer and Worker Protection was formerly called the New York City Department of Consumer Affairs. So you may see that term floating around still. But the name change was official a few years ago. But with this name change, nothing changed in terms of enforcement, unfortunately. So the Department of Consumer and Worker Protection is still responsible for handling the Earned Safe and Sick Time Act, investigating employee complaints, and conducting investigations of employers' workforce. But the department is also responsible for enforcing some other up-and-coming laws here in New York City, which we'll touch on briefly. And these include the New York City Fair Workweek Law. This is the predictive scheduling law that we're seeing a lot in the news lately. It applies only to retail and fast food employees, though, as well as the New York City Artificial Intelligence in Hiring Law, and that's the law that restricts the use of artificial intelligence in hiring or promotional decisions without first conducting a bias audit. So those are two laws that are also on our radar. But even with the introduction of these laws, we do want to stress that enforcement of the Earned Safe and Sick Time Act make up the largest portion of the agency's audit responsibilities. And in terms of enforcement, the department is very, very aggressive in its approach, and they rarely allow for exceptions of the law. In fact, it's really not uncommon for the department to receive one employee complaint and then use that single employee complaint to open up an investigation into the employer's entire workforce. And we've actually seen this happen a few times quite recently. So what started as one complaint turns into a massive audit. And this is concerning for a number of reasons, which we'll get into in the next few slides. Next slide, please. So here you'll see a bunch of statistics. This is what the department released. It goes through the years of 2017 through 2021. And there's a few important points that I want to highlight here because this kind of sheds some light into the department's tendencies and what they're really looking at. So in the first box on your left, you'll see the total number of staff at the department. And you'll see that the number of investigators has increased in more recent years, along with the total number of attorneys, researchers, and other staff members who work on things like intakes. And I just wanted to highlight this because it really shows that the department is ramping up its staff to handle paid sick leave complaints and investigations. So really, if anything, audits are just going to continue in more recent years. There's no evidence that the department is going to slow down its investigations anytime soon. And in the second box, you'll see the total number of intakes from 2017 to 2020. And this is a little misleading because you'll see the total number of intakes decrease by more than half in 2021, but we don't expect this trend to continue. And that's really because this takes place during the COVID-19 pandemic, and a lot of employees were working remotely during this time. So the need for sick leave was less prevalent. And even when people were sick and needed time off from work, chances are they came down with COVID-19. And if you remember, New York State has COVID-19 leave, so if an employee did come down with COVID, there was specific leave that they were eligible for, COVID-19 leave. So chances are during this time, people were either working remotely and didn't need paid sick leave, or they had COVID and they used COVID leave. So the number of complaints to the department is lower. But as employees return to work, which we're seeing a lot right now, we expect the number of intakes to rise. And the department may know that this is inevitable, which is why they're increasing its staff in 2021. And then lastly, on the columns on your right, this kind of just goes back to the point that the department spends a large majority of its time on earned safe and sick time compliance. And that's kind of why we're going through this today, because it is so prevalent, especially in the last few years. You'll see that the number of complaints received and investigations opened are more than double other laws that the department enforces, such as the Fair Workweek law, the freelance law, commuter benefits, such as those things. So that's just something that we wanted to highlight as well. Next slide, please. And here we have some more statistics that are tailored to earned safe and sick time audits. So again, on the left, you'll see that the number of complaints is decreased, but again, we really don't expect this to continue because this really goes back to employees working remotely and using COVID-19 leave instead of earned safe and sick time. So that kind of explains that. But what's not on the down is the total of investigations opened, as well as the total amount of restitution awarded to employees, which is the amount of money that's actually given to employees after an audit, and the total number of penalties that employers were liable for things like violations. Essentially, how much money these investigations are costing employers. And this is very important for a few reasons, but in 2021, almost $3 million in restitution alone was paid to employees on average, which is more than triple the amount of restitution that was awarded in 2020. So again, this goes back to the aggressive tendencies of the department. They don't allow exceptions. And this is where we go back to, if there is one complaint from an employee, we can get into an entire investigation of an entire workforce, and depending on how many employees are part of that workforce, we could be looking at restitution amount in the millions. It's very common, actually. And then also concerning is the fact that the amount of penalties employers were required to pay for violations also increased in 2021. And again, we only expect that this is going to continue. So So that's why it's important to understand the most common types of complaints that the department receives, so that way we can ensure compliance with the law and avoid audits as much as possible, or even reduce the amount of restitution or penalties that are owed. So on the right, you'll see the types of earned safe and sick leave complaints that the department receives each year. Some of the biggest complaints involve employers not paying employees for the use of safe or sick leave, retaliation, failure to maintain a written sick leave policy, and complaints regarding accrual of leave. So with this in mind, we'll just go through some key points. Of course, the law is much nuanced than this, but just some points to keep in mind is that employers need to make sure that they are paying employees at their regular rate when they use safe or sick leave under the law, and they're not taking any adverse employment actions, and that would include things like demoting, firing, giving less favorable assignments, or any other adverse action for an employee requesting or using safe or sick leave under the law. So if an employee requests to use sick or safe leave, you can't give them a less favorable assignment in return. That is considered a violation of the law. In terms of a written policy, all employers covered by the law must have a written paid sick leave policy that is distributed to employees. And there's a number of requirements that must be met, but the policy must describe the terms and conditions of accruing leave, as well as how employees can go about requesting or using leave. And the regulations and rules concerning sick leave are constantly changing in New York City, so it's important to just refresh yourself every now and then to make sure that nothing has changed. And of course, Seyfarth keeps up with that, so we're here to help as well. And then also, accrual is another important point that we receive a lot of questions about here. So employers can either front load the required amount of hours to each employee's paid sick leave bank at the beginning of the year, or they can follow an accrual method where employees can earn no less than 1 hour of paid sick leave for every 30 hours worked. And there could be administrative burdens with each method, and employers can choose a method in between if it works best for them, and we're here to help with that decision. But the most important thing to remember is that in no event can an employee earn less than 1 hour for every 30 hours worked. So that's an important thing that employers must track as they're going along. And we also note that employers must inform employees of their accrued, used, and total leave balances either on their pay stub or through an employee accessible electronic system. And this amount must also include any carryover from the years prior as well. So that's another thing that must be distributed to employees. And again, this is a broad overview. There's much to this law that we're happy to discuss. Next slide, please. So as we talked about, there's a lot of requirements in New York City that employers must follow to make sure that they are compliant with the Earned Safe and Sick Time Act. And it's really easy to make a mistake with all of these requirements, which is why we're seeing such high restitution and penalty amounts being imposed after department audits. You'll see here that in 2021, the cumulative amount of restitution and penalties was $19.9 million. And again, this was during COVID when less people were requesting to use leave. So we only anticipate that this number is going to drastically rise in the years coming. Next slide, please. So now that we've discussed many of the common trends with respect to the department audits, what are some things that employers can do to help minimize risk if an audit is to commence? First, as we mentioned, one of the most important things is to make sure that your New York City safe and sick time policy is up to date. The New York City rules are constantly evolving, and New York regulations actually are going to be released soon, so having a current policy is key. And of course, as we mentioned, Seyfarth is available to help draft policies, review policies, anything like that. We have a great team who works on things like this on a daily basis. Another important thing is to make sure that you keep copies of all required documentation. The documentation is here on the screen. It's also in the law, but the department will certainly ask for you to produce this documentation if an audit is to commence. So it's important to create and maintain these to avoid penalties for noncompliance. So that way, when or if an audit is to commence, you're able to just hand this over. Because if you are not able to do that, that's automatic penalties that could have been avoided. And then finally, it's important to be proactive. So in the event of an investigation, feel free to get Seyfarth involved immediately. We have a great team that routinely handles these types of audits, and we've seen more favorable results the earlier we do get involved. So we're happy to assist in any way that we can. And with that, I'm happy to answer any questions or turn it back over to Kim.
Great. Well, thanks, Ashley. I guess your presentation was so thorough that no questions came in as of this time. But I'll just remind everyone, if you have questions for Ashley, then you can join her breakout room afterward. And so now we will turn it over to Grayson.
Awesome. Thank you so much, Kim. Good morning, everyone. Today I'll be covering some recent updates to New York's new hire notice and posting requirements, as well as the newly implemented updates to New York State's sexual harassment model policy. So first up, we have the updates on the new hire notice and posting requirements. Next slide, please. So just as like background, there are a number of notice and posting requirements under both New York State and New York City law. So if you have any questions about sort of what the exhaustive requirements are, please feel free to reach out to us. We're happy to walk you through a list, as well as just provide you a full summary of the requirements that are needed. So with that, there have been just a few updates in the last 2 years that are worthy of note. First up is the notice of electronic monitoring. So this law, which took effect in May of last year, amends the state's civil rights law and is focused primarily around protecting the privacy interest of employees in the workplace. So it requires every private sector employer to provide written notice to all employees at hiring if the employer engages in monitoring or intercepting by any electronic device of an employee's telephone conversations, emails, internet access or usage. This law stemmed largely because of the shift to remote working during the COVID-19 pandemic. Many employers have opted to utilize electronic monitoring tools for a plethora of reasons. And essentially this law requires the employers to provide notice in written or electronic form. And that notice requires you to advise the employees of any and all telephone conversations, email communications, or internet access and usage that may be subject to monitoring. It also requires you to obtain the employee's signed acknowledgement of receipt, and notice must be provided more generally in a conspicuous place. So typically where you would provide all of your postings, you should include a notice of electronic monitoring as well. And it's applicable to all private employers within the state, regardless of size or entity type. Next slide, please. Another recent update is the requirement to post the Veterans Benefit and Services poster. So this took effect in January of this year, and it requires all public and private New York employers with more than 50 full-time employees to display the Veterans Benefits and Service poster in a conspicuous place, similar to the electronic monitoring poster. And all of your posters, it should be in one conspicuous place that's easily accessible to employees. And essentially that posting just provides resources, hotline numbers, as well as just information for veterans to understand their protections, benefits, and accommodations under New York State law. Next slide, please. So a common question that we receive when we are counseling clients is how to handle the notice and posting requirements in a hybrid environment. I think that this is a new topic that stemmed from the pandemic. And so we wanted to ensure that we kind of gave you just an overview of guidance that was provided by the U.S. Department of Labor. And again, if you have any questions about it, or if you would like us to walk you through it further, please feel free to just reach out to us. And so the U.S. Department of Labor provided guidance on complying with its notice and posting requirements when employees are working remotely. It's under 3 different brackets. So first being a continuous posting requirement for notices that are required to be posted continuously. So with those notices, if it is required to be posted continuously, you can post it electronically, and an electronic posting is acceptable where all of your employees are exclusively working remotely. all of your employees customarily receive information from you via electronic means, and all of the employees have readily accessible access to the electronic posting at all times. This would ensure that the posting satisfies all the statutory and regulatory requirements, and that such postings are continuously available to employees. In the event that you happen to have on-site employees and remote employees, you should supplement a hard copy posting requirement as well. So keeping it in a conspicuous place so that employees have access to it when they are on site. Next slide, please. For notices that are required to be given to employees individually, you want to deliver those notices via email if that is something that you customarily do. So if you customarily provide notice and updates to your employers via email, you can provide them with individual notice via email as well. This would be consistent with the Wage and Hour Division's existing regulations, which allow electronic delivery of required communications only where employees already regularly use and receive such electronic communications. Next slide, please. Okay, and then the last bucket of this guidance falls under access. So if an employer seeks to meet a worksite posting requirement through electronic means, such as an intranet site, or maybe you have an internal website that only your employees access or a shared network drive, the electronic notice can be provided there as well, and it would be as effective as providing a hard copy notice to your employees. So essentially, if you utilize some internal network site and you utilize it often, and that's a normal form of communication with your employees, you can provide electronic notice through there, and it would be just as effective as providing that hard copy notice to the employee in person. So a determination of whether affected individuals can readily see the electronic posting depends on the facts. And so the Wage and Hour Division kind of takes it up on a fact-by-fact case basis. And essentially, the biggest thing is that you want to ensure that employees are capable of accessing the electronic posting without having to specifically request permission to view a file or access a computer. And you want to ensure that, again, it's easy for the employees to access if they need to access it for any reason. And then, again, consistent with existing regulations, the Wage and Hour Division will not consider electronic posting on a website or intranet to be effective means if the employer does not customarily post the notices to affected employees or other affected individuals electronically. Next slide, please. So moving ahead, I'm going to spend a good bit of my time now talking about the newly implemented updates to New York State's model sexual harassment policy. So next slide. Since 2018, New York employers have been required to maintain a written sexual harassment policy and provide annual anti-harassment training to their employees. To help comply with these requirements, the New York State Department of Labor has issued a sexual harassment model policy that provides a template to ensure that employers' policies meet the standards required under the state's labor law requirements. As an employer, you are able to adopt your own policy. You don't have to use the model policy. However, you want to ensure that if you do adopt your own individualized policy, it has to either meet or exceed the minimum standards set forth by the Department of Labor. You also must provide notice to your employees at the time of hiring and annually during your anti-harassment training. You must provide them with a copy of the policy. Now with that, last week, as Kim mentioned in the introduction, the state DOL finalized updates to the model policy. So I'm going to review some of these updates for you. And again, if you have any questions, please feel free to drop them in the chat, or you can connect with us offline and we'll be sure to get those addressed for you. Next slide, please. So first up, the revised policy now provides that gender-based discrimination can be related to or affected by other identities beyond gender. It also provides a detailed explanation of gender diversity and includes definitions of cisgender, transgender, and non-binary persons. A second addition is updates to the legal standard. So it adds that sexual harassment does not need to be severe or pervasive to be illegal, and that it can be any harassing behavior that rises above petty slights or trivial inconveniences. Second, it adds that whether conduct is harassing will be considered from the standpoint of a reasonable victim of discrimination with the same protected characteristics. And then third, it adds that the intent doesn't matter. So if you don't have the requisite intent, or if an employee doesn't have the requisite intent of harassing another employee, it doesn't necessarily neutralize a harassment claim. So intent would not be a defense to a sexual harassment complaint. Moving along, additional updates are under the non-exhaustive, list of examples of sexual harassment and retaliation. So they provide a pretty extensive list, I would say, of examples of sexual harassment and retaliation. And so it varies from physical acts of a sexual nature, sexual oriented gestures, noises, even, with jokes regarding an employee's sexual or gender expression, repeated requests for dates or romantic gestures, asking employees to take on traditionally gendered roles, such as asking a woman to serve meeting refreshments, etc. Definitely encourage you to take a look at the list that they provide, as it again varies and it's pretty expansive, although non-exhaustive. So examples can fall outside of the list that they provide. There's also an emphasis on remote workplaces. And so they make clear that harassing behavior can happen in any remote environment, such as virtual meetings, messaging apps, or even after hours on personal cell phones. It also extends to virtual workspaces. So an example that they provided was materials, inappropriate materials that may be visible in the background of one's home during a virtual meeting as well. Next slide, please. There's additional language that's been added to the supervisory responsibilities section of the policy. And essentially it relays the message that supervisors and managers should not be passive and wait for an employee to make a complaint of harassment. They should be mindful of the impact that harassment has on employees and the subsequent investigation that it has, and handle such matters with sensitivity. And one of the new additions to the policy completely was the addition of a section on bystander intervention. So this is a brand new section, and it explains 5 standard methods of intervention that can be used if employees witness harassment or discrimination. I'll run through them really quickly with you. And again, if you have any questions, feel free to just flag them for us. So first up is a bystander can interrupt the harassment by engaging with the individual being harassed and distracting them from the harassing behavior. A bystander who feels unsafe interrupting on their own can ask a third party to help intervene in the harassment. A bystander can record or take notes on the harassment incident to benefit a future investigation. A bystander might check in with the person who has been harassed after the incident, see how they are feeling, and let them know the behavior was not okay. And if a bystander feels safe, they can confront the harassers and name the behavior as inappropriate. When confronting harassment, physically assaulting an individual is never an appropriate response. Next slide, please. Another addition to the policy, or revision rather, to the policy is in the section of legal protections and external remedies, which provides the state's confidential hotline for complaints of workplace sexual harassment, along with details on how to file a complaint with the State Division of Human Rights. And then finally, the revised policy adds a conclusion section, which states that while the focus of the policy is on sexual harassment and gender discrimination, the human rights law protects against discrimination in all protected categories. And we've always advised clients that their policy should include these categories. But if you have any questions, or if you would like us to take a look at your policies, please let us know. Next slide. As a helpful point, the New York DOL has issued model forms, including a model policy and model training video. The video meets all of the New York State training requirements, except for it being interactive. However, the Department of Labor does provide guidance for employers on how to meet this interactive requirement. All employers are also required in their policies to have a complaint form for employees to report alleged incidents of sexual harassment. So if you don't have one in your policy, definitely reach out to us and let us know, because we want to ensure that you have full compliance there. As a best practice, you should customize your policies and training materials to your specific organization. And so if you have any specific questions related to your specific organization, please let us know. We have a great team who works on handbooks and policy review, and we'd be more than happy to take a look for you. Now, with that, do we have any questions, Kim, or should I pass it over to Nick?
Yeah, so just actually a few questions came
Okay.
in. So with regards to the electronic monitoring, if a company does not actually actively monitor, but they just give their IT department the ability to like dig up old emails if the need arises, do they still have to provide the notice?
That's a great question. So the notice is required when you actively do
Right.
the monitoring. Yeah, when you actively do. It doesn't make a distinction in terms of whether you would, what the requirements would be if you had access to. However, if you do actively engage in electronic monitoring, you intercept employees' emails, messages, etc., you would need to require the notice then.
Right, right. And, you know, the only exclusion really that we see in the statute is where they say if you're just monitoring for volume or maintenance or something like that, then that's not considered, you know, actual monitoring that requires the notice. But if you are monitoring any activity or communications of employees, then you should distribute the notice. But if your company's not, like you said, Grayson, if the company's not engaging in actual monitoring, then the need doesn't arise. Then another question came up. When are the sexual harassment policy requirements effective?
So the policy is effective immediately. So as of April 11th, 2023, your policies would need to be in conformity with the minimum standards set forth by the New York Department of Labor.
Okay, great. And then another question, if a company's in the process of building a new company intranet by posting the required legal posters and notices, once it's rolled out, it will meet all the requirements. But does the company, in that case, do they need to include an announcement of some sort that formalizes it or, you know, notifies the employees?
Yes, as a best practice, you want to ensure that your employees know that that is now going to be the new place where they would have access to the notice and postings. As well as you want to ensure that, you know, every time a new notice is updated or every time a new posting is posted there, you would want to ensure that you roll that information out to them in an email or some form of communication.
Great, thanks, Grayson. That's super helpful. And
Thank you.
Takes care of all of the questions. One question did come in actually for you, Ashley. We'll just turn back to you for just a moment. A client wanted to know where they can find the most revised and up-to-date New York State sick leave requirements. A good resource.
So the best way to find that would to just Google the New York State Earned Safe and Sick Time Act. You'll see the official city website. On there, they will have FAQs that are really, really helpful because they'll go through commonly asked questions and then give you examples and explain the law a little bit better. On there, you'll also see the regulations and the law as well. As of now, I don't believe, I checked this morning, I don't think the regulations are out yet, but those will be posted there as soon as they are.
Terrific, thanks so much. So with that, we will now turn it over to Nick.
Hi, good morning, everyone. My name is Nick Lucier. I am here to present on the New Jersey Temporary Worker Bill of Rights. Before I do that, I just want to thank everybody for being here and thank the IT people and our marketing department for putting this together, this awesome event. I'm learning a lot. But with that said, let's dig into it. We can stay on this slide for a little bit. Governor Murphy signed the bill into law on February 6th, but its success was far from certain. The bill was the subject of intense lobbying from workers' rights groups, including unions and industry groups concerned with the breadth of the new law. In fact, for this bill, 3 times was not the charm, nor was it 4. In fact, well, on the fourth vote, before the fourth vote, there was a conditional veto. So it took a little bit for this to get through. That said, it governs third-party temporary help service firms. It's a mouthful, which are firms that help third-party clients in handling temporary or excess or special workloads. As I've hinted, though, there are obligations for third-party clients as well. So let's delve into the law, see what all the commotion was about and why it took 4 votes and a veto to get this through. So I just want to say at the outset that the law is expansive. Just when you think that it might be it, there's a little bit more. This could easily be a 30 or 45-minute presentation by itself, but I'm going to give you the highlights. And to the extent you have any questions, please join me in the Q&A afterward. So kicking it off, we have the notice provisions. So anytime a temporary help service firm agrees to send a person to work, they need to provide over a dozen points of notice in English and the worker's primary language. And I just want to note that if at any point some of these provisions or these notice parameters change due to circumstances, there's also a requirement to update them in a certain amount of time. But as the slide demonstrates, notice points include the name and nature of the work, as well as a description of the position and whether it will require specialized training or equipment, the wages offered, the length of the assignment, and the amount of sick leave available. So for those of you who might operate in this space, you might notice this is a familiar list. In fact, this is very similar to the Illinois Day and Temporary Labor Services Act. It seems that the New Jersey legislature borrowed from Illinois here. Next slide. But moving on to one of the more consequential provisions in the new law, we have the rate of pay and pay equity provision. I'm not going to go too deep into this provision, but I just wanted to know that it requires temporary laborers to be paid at a rate no less than the average rate of pay and average cost of benefits or cash equivalent for temporary workers performing substantially similar work. So it's important to evaluate job descriptions of not just the permanent workers, but also the kind of tasks and responsibilities temporary workers will be performing. And you need to evaluate whether there's substantial overlap. You may need to pay them comparably. And just as another point of best practice, this could create some tension in the workplace as temporary workers will end up being paid comparably to permanent workers. So just keep that in mind. Next slide. The last highlight I wanted to bring to your attention is that the law eliminates certain deductions. The law seeks to ensure temporary laborers meet the New Jersey minimum wage. The New Jersey minimum wage is $14.13. They must meet that wage independent of any deductions taken, bar a couple. The law will require disclosure of any deductions and prohibit certain deductions outright, like deductions for transportation. Okay, so we've talked at length about some of the provisions, and I imagine many of you are thinking, does this apply to all workers? And the answer is no. We can go to the next slide. Oh, next slide. So instead, it does not apply to all workers. Instead, the New Jersey legislature used a novel way to delineate who is covered and who is not, and it is sure to cause some headaches. The law applies to employees in a designated classification placement, and the contours of that definition are shaped by the Federal Bureau of Labor Statistics standard occupational classification. Now, over a decade ago, I was sitting in a labor economics class poring over Bureau of Labor Statistics data, and I thought that it was the last time I'd ever have to deal with it. But here I am, over a decade later, and I'm dealing with the BLS SOC again. I'll refer to it as the SOC throughout. The New Jersey legislature defined the applicable jobs through the SOC, and it referenced certain job classes within the SOC by macro classifications. As you'll see, there are a bunch of classifications on this slide, and there are approximately 23 macro classifications in the BLS SOC. And then within those 23 macro classifications, there are 867 detailed job descriptions. So as you can already tell, this is a bit of a lot. So it's unclear whether the New Jersey legislature is adopting in full all the principles of the SOC. But as you see, these classifications are things like food preparation, personal care, construction and production occupations, among others. Breaking it down into the specific classifications, we can go to the next slide. That are included and excluded for now. Those that are included are security guards, dishwashers, bakers, and it's not on the list, but housekeepers are in as well. Excluded are those that you would traditionally think of as office workers, secretaries, administrative assistants, data entry. Those are the kinds of jobs. If we can go to the next slide. I think this quote generally describes the sentiment, the kind of workers covered by the new law. It is by one of the law's original sponsors, and focuses and kind of highlights how the law focuses on low-wage industrial workers. But as demonstrated on the previous slide, industrial and low-wage worker may not aptly describe all the workers covered by the law. And so with that said, we can go to the next slide. I want to dig into the SOC because this is a portion of the law I find so interesting. One of the issues of the New Jersey legislature kind of left open and that they're going to have to deal with is the fact that some of these job classifications that they included contain these subclassifications that I've been referring to as catch-all or residual subclassifications. I've included some of them on this slide. Essentially, the BLS intended the SOC to be a statistical tool, and where a job cannot be categorized into a specific job description, they created a all other category. So you may go through the list of named classifications and job descriptions, feel comfortable about excluding a category of workers from the notice, but then all of a sudden you see this residual catch-all classification and you're not so sure what to do. We can go to the next slide. Well, fortunately for you, there is a manual on that. And while I realize it might be cut off where this arrow is pointing to, but that manual is approximately 285 pages. So I suppose right next to your to-do list for the day, you'll have the wonderful BLS SOC manual sitting right there on your desk. But it's unclear whether the New Jersey legislature is adopting the standards and principles within this manual. But we can go to the next slide. That said, if it does apply, there are some issues that jump right off the page. First, like I said before, the Bureau of Labor Statistics never intended this to be used in a regulatory, administrative, or tax program. They're pretty clear this is supposed to be used as a statistical tool. Second, as described before, it's intentionally vague. It recognizes jobs can often be categorized in more than one place. So it created principles of classification that might make sense for statistical purposes, but are harder to administer practically. For example, it might be hard to break workers' activities down by specific tasks, but that is one of the tiebreakers, if you will, the BLS demands in its manual. Next slide, please. The end all be all of this is that whether a worker is included or not is a context-driven analysis. And I have an example here that I pulled recently. I think it's helpful to get an idea, lay of the land. So let's think of an IT worker. The IT worker, under normal circumstances, is someone, if they're in the Bureau of Labor, the New Jersey legislature included within the coverage of the law and within the scope of the law, a worker who repairs, maintains, among other things, word processing systems. Now, one of the not covered positions, a computer user support specialist, is someone who provides assistance for word processing systems. And so the line between maintaining a word processing system and providing assistance to for a word processing is not exactly clear. It would probably come down to how much time is spent doing one of these tasks versus others, as the included category tends to be more manual, tends to be more like repairing machines. But with that said, it creates an issue that we might see, as the law goes into effect. And finally, next slide, please. I just want to highlight there are joint liability provisions. So even if you're not a staffing agency, some of the provisions may apply to you, specifically the provisions dealing with permanent placements, pay equity, among others. The law takes effect August 5th, 2023, but certain provisions like the anti-retaliation provisions kick in on May 7th, 2023. So we are eager to hear if we're going to get any more guidance from the New Jersey Department of Labor. We are going to keep our ears wide open to see what happens, but I just want to thank you everybody for being here, and I hope to see you at the Q&A.
Great, thanks, Nick. So just a few questions came in. This one, I know you did answer, but the question came in before you answered it, but I think it's just good to clarify anyway. Does this New Jersey law apply to all industries or only certain ones?
So it's important, I think, to just at the outset say it's not an industry specific law. It goes by job classification. So it doesn't apply to certain industries, rather it applies to certain job classifications. So whether, for example, you have security guards, but you're in the hospitality industry versus somebody who might be, I don't know, has security guards as in provides community service, say like a homeless shelter, something like that. They would both be hypothetically covered under the law. That the security guard classification would come under the auspices and scope of the law.
Okay, great. And is it the employers or the temporary staffing agency's responsibilities to ensure compliance with the law?
Yes, that last slide, I'm sure that came in before the last slide. There is some joint responsibility, as I was discussing, and with respect, I believe it's section 7 of the law contains the joint liability, but that's the pay equity. There's a restriction, like I said, I gave you the highlights today, but there are other restrictions on interfering with permanent placements that also carries the joint liability section, if I remember off the top of my head correctly. So yes, you need to be aware not just of what the staffing agency is doing, but also your own policies and how you're acting.
Right. You know what? There's another question or two. Before I get to those, I just wanted to announce the CLE code for anyone who is interested in using it. For credit, it is SS as in Seyfarth Shaw, and it is 1649. So again, it's SS 1649. And also just a reminder that we will be sending out to everyone registered for this event. We'll be sending you all a copy of the PowerPoint slides today, because I know those questions came in. But just back to the substantive questions for a moment, Nick. Also, if a company has temporary workers that reside in New Jersey, but they do the bulk of their work in New York, does the law still apply?
So the law isn't explicitly clear on this, but we expect it's only going to apply to the work done in New Jersey.
Okay. Great. And with regards to the job codes that you listed, I mean, that's basically only if a company can sort of slot its workers into those jobs listed. Is that the ones that they have to certify?
Great question. That is section 8 of the new law, and so it seems broader than that. It actually says if you meet the definition of temporary help service firm, then you need to certify. It doesn't say, so long only when you have a person in a certified designated placement, then you certify. It just says temporary help service firm needs to certify. So it could be broader than that.
Okay. you know what, I'm going to go back to the whole living, working question a moment ago. What about if the temporary workers are living in New Jersey and working remotely, but the company is based in New York?
That is another great question. So again, the law not so clear on this, but we expect if the work is being performed in New Jersey, then if the work is being performed in New Jersey for out-of-state people or out-of-state entities, we're not exactly sure what the interplay is, but if it's being performed within New Jersey, then we expect the law to cover them.
Great. One last question came in that the client is a third-party vendor with long-term contracts with their clients, but at times they've utilized temporary help from temporary agencies. Do they have to provide job descriptions to the temp workers for the jobs that they'll be performing for them?
So first off, the long-term contract issue is interesting because that's one of the biggest questions we get right now is whether, long-standing contracts are going to be included under the scope. And we think they will, just by the spirit of what the legislatures were saying when they passed this law. They were very concerned with permit temps, what they called a permanent temper. And so we think that the scope of the law will be including even long-standing, staffing contracts. That's just number one. Number two, as to whether you're required to provide job descriptions, nothing requires you to provide them. However, I understand the question because you are in a little bit of an awkward spot, right? Where you need to make sure that the pay equity provisions are being adhered to on both sides and that you understand who they're staffing and the tasks that they're doing, and also whether or not your people are performing the same work as them. There's nothing that says you have to provide the job descriptions to them. So I guess the simple answer is no, but I think to the degree you need more help with that, we're happy to discuss.
Great. Thank you. I think for now, that's all the questions that have come in, but we would really like to invite all of you to join us in our breakout rooms, which we can actually enter into, just in a few moments. So that concludes our presentation today, and we thank all of you for being here. And then you will see a prompt come up on the screen. So please choose the room you'd like to enter, and you'll be able to ask your questions live to our great presenters today. Thanks.